Well, thank you so much for this fantastic keynote talk. And I would like to invite the session 3, Control over Personal Data under GDPR, to the stage. We're having Brent Mittelstadt from University of Oxford, Florent Tovnen from ITSL, University of Zurich, and Carlos Afonso Souza, ITS Rio, and Freya van den Boom, Bournemouth University. Oops.
That so many people are still here and still listening, and thanks again to Malavika for a very fantastic talk. I think it provides a fantastic introduction. Just so you know, we've changed up the lineup of the speakers slightly to adapt to the existing talks that are within the session of the different speakers. And so we try to make sure that you have both an interactive and a slightly more open conversation. So please, if you have questions, we want to hear from the audience as well, and we will do a Q&A at the end of it. Apart from missing the different elements of Malavika's Q&A, you can, of course, ask questions about the general theme that you've already heard about. So without further ado, first speaker, Kyung, the floor is yours.
Yes, I think in this session, we are supposed to talk about selected issues. We are supposed to deep dive on selected issues around GDPR, and the issue I chose is right to be forgotten, which has been expanded to right to erasure under GDPR, where information that some people desire to force into oblivion are not only delisted from search results, but also erased from the original database. I do believe in very strong data protection law for everywhere. I also have led several litigations with the civil society organizations against the largest platform companies in Korea and also telecom companies under the country's data protection law. But one area I believe GDPR has gone wrong is right to be forgotten. Right to be forgotten is based upon this new idea of privacy as opposed to classical privacy. This new idea of privacy that includes that includes even the voluntarily shared information. It allows people to revoke their previously given consent and claim back from other people's control, or from or reclaim information about them from other people's memory and other people's control when the information becomes, quote unquote, no longer relevant. Now, Malavika talked about social credit rating. Now, social credit rating, I think, is a problem because it forces people to share otherwise privately financial information. But right to be forgotten does is it prohibits other private individuals from sharing and mentioning the information about data subjects that have been legally made available. So under the issues like, forced coming out, right? Coming out about sexual orientation usually, forced coming out, revenge porno, sexual victimhood, all these issues can be taken care of by classical privacy rules that protect only the information that were confidential by people's choice. But the new concept of privacy under the right to be forgotten tries to force into oblivion the information that are not so private after all. For instance, Google is receiving right to be forgotten requests, millions each year. Now, the majority of them are reputational information about professionals like lawyers, doctors. You know, I hate these doctors, I hate these doctor services, blah, blah, blah. I didn't like lawyer service, blah, blah, blah. And a lot of requests, the majority of requests, right to be forgotten requests, are made against those comments. The reason is that comments about professional services are not clearly false nor clearly true. It is just opinions that are not subject to verifications. So there is a dispute. Now it's clearly legal information, but there is a dispute between two subjects, and right to be forgotten's answer to the dispute is forced into oblivion. Just delist so that it cannot be searched. Whenever you talk about right to be forgotten and the value of it, you should think about who is being forced to do the forgetting. It is ourselves. We are trying to blind ourselves from memory about ourselves. Now, this is different from, for instance, expunging criminal records. Now, criminal records, it's a mandatory existence. It is an imposition on people's lives by the sovereign, by the state. So expunging it has a value in terms of freeing people from the weight of that the criminal records. But what right to be forgotten does is not freeing people from the state imposition, but what right to be forgotten is doing is prohibiting private people from sharing information about one another. Why do we have this new concept of privacy under the banner of right to be forgotten? I believe the real motive behind right to be forgotten is people's desire not to be discriminated for their past frivolous wrongs or conduct. Now, if that is the real motive behind right to be forgotten, I think blinding ourselves from one another's wrongs is not an effective way of addressing or combating discrimination. Under current concept of right to be forgotten, the supposed wrongdoers can censor search results about them, or under the new GDPR, not just search results, but original database, just because they themselves think that certain past conduct or certain information about their past are irrelevant to moral evaluation or ethical evaluation of their characters by others. But such self-serving censorship will only prohibit people from confronting the real forces that are fanning such discrimination. I think that discrimination against people for whatever reasons, it can be addressed only when the problems and its causes are known to the society. It's like I cannot be forgiven being Korean, right, unless I let people know that I'm Korean, right? Right to be forgotten cuts off that information and does not give other people to forgive me for being Korean. And blinding ourselves to information about other people's conduct is not really a proportionate way of combating discrimination either, because so data subjects, they themselves subjectively believe that some information is no longer relevant. So it's the temporal relevance, and wants other people to forget about that information. But to other people, that information may be really, really important in ethically evaluating that data subject. The value of data does not reside in itself, but in the eyes of the beholder. The fact about one's auction of, the fact about a Spanish lawyer, the information about a Spanish lawyer losing a house on judicial auction may not be considered relevant by himself because he's now a successful businessman. But people, for instance, studying the Spanish judicial profession may find that fact, that case, very relevant in their research. And I mean, I can go into more cases about how information about others are important to people trying to evaluate them. I mean, how important that information can be to other people trying to protect themselves. I think the more effective and proportionate way to fight discrimination is allowing more information to be made available about people so that others' perceptions can be more contextualized. For instance, in Korea, fact that you were divorced once would have been the subject of a right to be forgotten request, but no longer so. Why? Because now there's more information about other people's divorces. Now, that stigma has disappeared because more information has been made available, and also that information was used by feminists to persuade people about why it's okay to fail, to undo a marriage. Now, popular defense of right to be forgotten is that it does not apply to publicly interested information. But public interest is in constant flux. Suppression of seemingly insignificant data may suppress the possibility of public discourse because revelation of important public facts is often made possible only by assembling seemingly irrelevant facts, right? So in the global south, where the legacies of military dictatorship or colonial rule have still not been removed, sometimes you need all the information, not just about famous people or high-level officials. You need all the information about even lower-level officials who have collaborated with the colonial rule or dictators to really undo and cleanse the society of the legacies of past oppression. So I'll stop there as the moderator requested, and we can continue the discussion.
Thank you very much. So just a quick question, because if I understand you correctly, you completely disagree with Helen Nissenbaum's concept of contextual integrity, which is to say that essentially the contextual relevance should be decided not by the individual whose data it is, but by society, and they should be able to evaluate that. Is that a correct interpretation of what you just said?
I agree with the Nissenbaum that it is because integrity is contextual, the information, more information should be left out there. Now, I mean, what?
But that's not what she says. It's the opposite of what she says, what you just said. That's why I'm asking. Because contextual integrity is used as an argument to privacy, that you should have control over the contextual integrity of your information. That's why I was so interested that you disagree with her. Well, it seems to be from your presentation. But maybe you don't.
Well, let's, I mean, how do you build the context unless your information is out there in the context of other things? I mean, that I'm a professor is made possible only because there are students who come to listen to my lecture. Mm-hmm. A professor is a communal concept. An identity is not controlled exclusively by me.
But just to understand, so basically you're arguing that the contextual control should be with the society and not with the individual.
Exactly.
Perfect. Ronaldo, up next. No.
So good afternoon. I'm going to go very quickly with this one. This is mostly to react to Malavika's presentation and to some of the KS remarks. So please do excuse me if I end up like skipping some of the slides. I want to make sure that we stick to the time that we are assigned. So this is just to plug in on the idea of a right to be forgotten as contemplated at the GDPR, and how this might have a different impact in different countries. So this is my usual like 10 challenges in the future for the right to be forgotten, and or some 10 points that we should pay attention when we address the issue of the right to be forgotten. Some of them might seem like slightly more like critical than the others, but that could give us a good framework on how we move forward on the discussion of the so-called right to be forgotten. So I'm going to go very quickly to some of those 10 points and making the connection to Malavika's and KS points, going through especially some insights from Latin America. So first things first, there is an issue on the concept, since we're talking about the right to be forgotten, and most of the times if we're thinking about in this very concept, there's a promise that is tricky to be delivered, because what you have either be on erasure, delisting, you don't get to forget the very same thing that is the object of the action that you are commissioning. So it's important to remember that like no decision can order something to actually be forgotten. Forgotten is the result, or something to be forgotten is the result of a previous action. So there is something for us to think about, because this is not like a Men in Black movie in which like two guys weirdly dressed that way come with a thingy in front of you and then you suddenly forget about something. So I really like this question that was posed by Catalina Botero, the former rapporteur for freedom of expression at the Organization of the American States, when she questions like why we get so much attached to the very same concept of the right to be forgotten. Is that because this is more an emotional category than legal or juridical concept as well? But this is something for us to think a bit. I'm going to go quickly on some of my next points. One is one that people usually refer to, which is the architecture of the internet, end up tending more to remembering than to forget. So to remember is the rule. The third point is the point that KS is making on how and who get to decide what we're going to forget. Is this a decision that is an autonomous and individual decision of what should be forgotten, or there is any social constraint that might make this a little bit more complex? And just to give you guys an example, so this is our former president of Brazil, President Lula. He, back then, when he was working in a factory, he got himself into an accident and he ended up losing one of his fingers. And he filed a lawsuit for damages because of this labor accident. This is not a right to be forgotten case, but might serve as a good analogy. Because like all the lawsuits and the process were piling up in a room in the courts, people end up thinking that it was a good idea to, well, let's clean our archives. And those like very old processes that nobody cares anymore, they are already decided, let's put them all to the incinerator. So those processes were all eliminated. The thing is, that was only a lawsuit for damages of a guy who lost a finger in a factory like back then in the 70s. But this guy ended up turning out to be the president of Brazil like 4 decades after. How interesting will it be from a historic point of view to have access to the lawsuit in which the president of this one country end up claiming damages from an accident. And this process is lost. This is not a right to be forgotten case, but it's interesting for us to reflect upon the idea on what are the standards and how could we, if we could, decide ex ante if something is worthwhile to be remembered or something could be simply forgotten. One specific challenge that I think is peculiar from the decision from the European Court of Justice on the Costerra case is the empowerment of companies in deciding what should be indexed or de-indexed, could be uploaded or removed. And this is really interesting because I know that different countries might have different ways to tackle the so-called right to be forgotten. But it's interesting to see that by the end of the day, we need to be super careful on how we handle the balance between how much power are we granting to companies to decide what is possible to be delisted and forgotten, and how do we want either governments, courts, to have a say in this type of question. I have a couple of questions on enforcement. One is the question on global enforcement, and this is a question that starts in Europe, but is spreading out to the entire world. So right now in Brazil, we have more than 15 cases in the Court of Appeals of the state of São Paulo, challenging the very same concept of if a search engine has to delist one specific result, does it need to do on the .br, on the Brazilian operation of this platform, or does it have to do it globally, or maybe to all Latin America? So that's the very same question that you now have under the European Court of Justice on the right to be forgotten case. It's being discussed and being challenged in Brazilian courts as well. And there is one thing that I think it's interesting for us to think about this global enforcement of the right to be forgotten, is that different countries will have different ways to deal with issues concerning speech. So, for instance, in Thailand, it's a crime to do some criticism to the royal family. If a judge for Thailand can apply this very same judicial decision to the entire internet, aren't we leveling free speech to the way in which one particular country end up dealing with freedom of expression? And I think this is something interesting for us to think about it. On enforcement, I think it's relevant for us to think about one very usual criticism that we find on the right to be forgotten, which is the idea of selective damage. So why the victim or the data holder is like filing this lawsuit against this one specific platform or search engine and not the others? Of course, huge market share by Google might be one of the obvious answers, but it's interesting for us to pay attention on this simple fact that you might get this one specific content erased from one platform and not the other. So you do feel damaged by having this content being in one platform and not in the other. So how can we conciliate those two scenarios? And of course, it's important for us to think on the usually referred to Streisand effect. For those of you who are not familiar, is that effect that is named after the actress Barbara Streisand that wanted to have her a picture of her home excluded from one website. I'm not sure if you guys have any interest in finding where Barbara Streisand lives, but once she ended up making a lot of effort in taking down this one particular photo, suddenly the internet seems to care, and people start like replicating this photo like everywhere, and suddenly, well, Streisand effect is something that is named after the simple fact that sometimes you end up remembering a lot more that one single thing that people try to forget. That happened in Brazil as well, in the case with the model, but I will skip that to go to the end of my presentation, thinking about issues concerning Latin America. I have 3 minutes here. Is that correct? On the count? Oh my God. So number 8. Are we rewriting history using the right to be forgotten? So especially in Latin America, this is something that bugs us a lot. The data protection officer from Argentina, Eduardo Bertoni, wrote a while this piece saying that the right to be forgotten will be an insult to Latin American history, but why an insult? So his idea is that a lot of countries in Latin America right now, they have a very young democracy. And in a lot of them, you have the emergency of those truth commissions. So people want to remember what happened during dictatorship periods. People don't want to forget. So when the right to be forgotten ends up being empowered, that might be in a direct opposition to what people want to do on the ground of those particular countries. And I really have to say, that's the case in Brazil, for instance, when we have amnesty law. So that definitely makes the crimes that were committed during the dictatorship times in the 70s and the 80s not be able to be retrial or to be judged right now. But at the same time, even if I can't bring this one person to court, may I not even mention that this one thing happened? So how right to be forgotten end up playing along with this idea of remembering what happened during one specific period of time in the history of those countries. And just going to the end, I have like 2 very quick points. One is for us to think how right to be forgotten will impact the protection of speech in relation to the debate on intermediaries' liability regime. You know that on different countries we have different laws concerning how platforms could be held liable for third-party content. How right to be forgotten might end up eroding a bit this idea of immunity that you might have. In the US, you have Section 230 from the Communications Decency Act. You have your own specific provision when it comes to Europe in the e-commerce directive. Brazil has one specific provision in the Brazilian Internet Bill of Rights. But since I'm concluding, I'm just mentioning that we have just browsed through some very wordy slides to say that in Latin America right now we have some cases that have been brought at Supreme Court in Brazil, in Argentina, in Colombia, in deciding on the right to be forgotten with very different results. Some of them denying the right to be forgotten, some of them ordering, not the search engine, but like the website of a newspaper, for instance, to not be indexed by a search engine. But I'll just conclude saying that now that we have this provision at the GDPR, which is Article 17, I think it's really interesting that we talked so much about the right to be forgotten having Article 17 of the GDPR as the source. But it's interesting to see that the name Right to be Forgotten is only there in the title. So, and that's one of the reasons I think that KS was mentioning about this confusion about right to erasure and right to be forgotten, and how do we move from here. And I'll just finish mentioning this piece from Daphne Keller from Stanford Center for Internet Society that address exactly how the right to be forgotten in Europe is being applied in Latin America. I will just leave you with those comments, because that brings me back to my first slide, which is to offer you those 10 points or 10 questions that we might want to address when we see how the discussion that is happening now in Europe under the GDPR regime might impact different countries differently. So this is not, don't get me wrong, this is not like a criticism saying that should be no right to be forgotten whatsoever. But I think that the way that we are framing this idea might be detrimental to the enforcement of some other rights. And I think we should definitely do some more efforts to work on right to reply, right to response, and other mechanisms that could be useful for us to make sure that we protect the person and, of course, privacy and data protection online. So that's it. Thank you.
Thanks for a fantastic presentation. I think after listening to both of you, I have this general impression that Europe isn't listening, and the whole of the world is saying how awful the right to be forgotten is and how we should think about these issues. And just, you mentioned it a little bit, but we also have people, I think, from the European Commission and others from all parts of Europe here. What should they be doing in very concrete terms, given the critique that you've mentioned, specifically to listen to these concerns that exist from the whole of the world that something needs to change?
So thanks, Ben. That's a very easy question to answer. But I would say I think we need to have a more balanced approach so far. I see a lot of people getting really excited with the idea of having the power to delete / remove / erasure every single information from the internet. Answering the question that I've made during my presentation, why people got so connected to the right to be forgotten, I think that's the promise that in a hyper-connected world in which we are generating information every single moment, as Malavika has said, right to be forgotten seems to be the promise to say, hey, we're giving you back control. But my criticism is that sometimes this idea of control, it's, well, not only might be flawed on some points and might be unbalanced when it comes to doing some comparison with other fundamental rights. And I'm really worried about free speech, freedom of expression, and especially I'm bringing this concept of dictatorship times in Latin America just to bring on this issue of how history is being told. And sorry, I'm being too long, but just to say, Brazil is going through elections time right now. We are going to elect our new president in the next 15 days. And that's pretty much not under the right to be forgotten, but that's pretty much one of the topics that we are discussing right now, because one of the candidates say all the nicest things about dictatorship times, the other quite the opposite. So I think Brazilians are allowed to have the opinions that they want to have, but at least both sides of the spectrum should have access to information to take their decisions and to decide like who is wrong and who is right. My concern with the right to be forgotten is that we are restricting access to this more like broad pool of information in order to people to take their decisions on a daily basis.
Thanks. I think that's really valuable, and it's also really helpful for me. I came into this panel as somebody who quite liked the idea of the right to be forgotten, and now after listening to both of your presentations, I'm not quite so sure anymore. I think more broadly it speaks to an idea that goes for the whole of this panel, that when we're talking about making decisions in one country or one region, or even like for the whole of Europe, there are very rarely people from the whole world present when the European Court of Justice or the European Court of Human Rights makes its decisions. And so maybe those judges should come to this conference and listen to some of our speakers, and then they would be more informed about some of the concerns and the challenges around the world. So, moving on swiftly, Brent, the floor is yours. Use the mic.
Right, there we are. So, thank you for having me. So my name is Brent Middlestadt from the University of Oxford, the Oxford Internet Institute. My day job is as a philosopher and ethicist, but increasingly I masquerade as a lawyer, or at least somebody who knows something about the law. And what I'm going to talk about in 10 minutes, hopefully, is whether we need sort of a refocusing of data protection law in the age of big data and AI. So in other words, is data protection law still accomplishing what it originally set out to? Is it still actually protecting the right to privacy in its richest sense? And what I'm going to argue is that in the same way that we felt the need to create a right to be forgotten, I think now in the age of big data and AI, what we need is a right of how to be seen. So the things that sort of motivate this push for a new right are examples like this, where Facebook has been accused of targeting young LGBT users with gay cure advertisements, so inferring sexuality from their usage of Facebook. More recently, this was within the past couple of days actually, Amazon has filed a patent to sort of give Alexa some additional features where it's able to infer something about your health, infer if you're sick, just from your speech patterns, from if you're coughing or sneezing, and then offer to sell you medication as a result of that. And personally, I find these sorts of inferences that can be drawn about you from just your daily behavior, this sort of data that you're emitting as a type of exhaust just from going about your daily life, to actually be really disturbing. Quite often because it's not clear what's actually being inferred about you. And really, to me, the problem of big data, the reason that we're so worried about it is because it severs that sort of intuitive link between your behaviors and how you're seen, or your behaviors and the consequences of those behaviors. And it's as a result of that sort of new risk, what I think is a novel risk of big data and AI, that I think a new type of right is required to really achieve algorithmic accountability, something that's being pushed for globally, usually in the form of sort of ethics initiatives, but in some cases also policy and legal initiatives. So on algorithmic accountability, sort of where this journey started to proposing a right to reasonable inferences was with the idea of explanations. So could explanations give us the sort of accountability that we hope for of algorithmic systems? As you can tell from the paper title, we don't think so. So myself, Sandra Wachter, and Luciano Floridi don't think so. We don't think that there actually is a right to explanation in the GDPR. But even if we do give explanations, even if we sort of are willing to give explanations, can they again give you sort of meaningful control over how you're being seen, over the decisions that are being made about you by automated systems? So this is a paper where we propose a particular type of explanation that rather than trying to explain how black box models work in their entirety, it just deals with your particular case. And it tells you a little bit about some of the key features for your particular case. And quite an exciting thing that happened with this is, so Google recently released a interpretability interface for TensorFlow. And so this is now embedded in that interface, so you can actually, if you're a user of TensorFlow, you can actually go in and sort of play around with the method and see if it works for you. But so that was sort of, that sort of exhausted our interest in explanations, at least for the moment. And so then we started to consider, well, even if you get an explanation that's still dealing with the decision, it's not dealing so much with the thing you really find problematic, which is the inferences that are being drawn about you from the data you provide. And so in this paper, which is 85 pages now, which I'm going to try to go through in the next 6 minutes, which is impossible, we propose that essentially the remit of data protection law needs to be refocused to protect privacy in its richest sense, because data protection is only one element of privacy. Privacy is also about identity, about self-representation, about autonomy, about decisional autonomy. And quite often these aspects of privacy are not being fully protected. So what we mean by an inference is essentially personal data that is generated about you that you have not directly provided to a data controller, or provided to a data controller that then passed it on to another party. So this is information about you that is inferred or derived from the data that you have provided or has been observed directly from you. So say some examples would be in the banking sector, I'm not a reliable borrower. In the insurance sector, Max may develop cancer in the near future. Or in employment, John is not a good worker and doesn't merit promotion. These are all examples of inferences, assessments, subjective judgments about the nature of the person. And some inferences can be verifiable in the sense of if I predict Max will get cancer in the near future, I can look at him 10 years in the future and see whether that actually happened. But others will not be verifiable, so in the sense of whether or not John is a good worker, that's going to depend on my subjective opinion of that. Now, the fact that inferences are of that nature, that they're quite often predictive, that they're quite often assumptions that are not verifiable, is a bit of a difficulty within the GDPR, because you have the right to correct personal data, to rectify personal data. You have the right to contest automated decisions about you. But how would you actually correct an assessment of you? Do you actually have a right to correct an assessment about you? So this is one of the questions that we went into the paper with. So to start answering that question, the first question you have to answer is, are inferences actually personal data? So there's some different views on this. The Article 29 Working Party, now the European Data Protection Board, they have a very broad view of what counts as personal data. So they distinguish between provided data, this is data that you provide or observe, and derived or inferred data, which is data that a third party creates about you. And they have this three-step model that basically says any information relating to an identified or identifiable individual that's about the person, that's used to assess the person, or that has an impact on the person counts as personal data. And they explicitly include subjective information, opinions, and assessments, and they think that the rights of data protection rights in the GDPR apply to these types of data fully. Now, a different opinion comes from the European Court of Justice, and there's two cases here I'm very, very quickly going to go through just because we don't have time. They have a different view. So in this one case, YS-M&S, they looked at, the case was essentially determining whether the legal analysis behind a residency decision, or behind an asylum decision in the Netherlands, counted as the personal data of the applicants. And essentially what they concluded is that the legal analysis does not actually itself constitute personal data. In a different case, in a later case, the case of Novak, this was an exam candidate requesting access to his examination script. They determined, they sort of adopted this three-step model of the Article 29 Working Party and said, well, any data that is related to a person in terms of content, purpose, or effect is personal data, and it doesn't matter if it's subjective or opinions and assessments. So they did actually find that the elements of the exam script were the candidate's personal data. So at the very least, there's not consensus around that, but we can say inferences are probably personal data in some sense. So if that's the case, how did the data protection rights actually apply to them? So in the case of the right of access, you do have a right to obtain a copy, obtain from the controller information about what data they hold about you, how it's being processed. But importantly, that right has to be balanced against the rights and freedoms of others. So this could be the rights and freedoms of other data subjects or of the company itself. So there are grounds there to actually deny a right of access, and I think a company could make a pretty strong case that if they created the data about you, then it may violate their commercial interests, it may violate, say, the privacy of others, depending on how the data is structured, to actually give you information about it. And the second would be the right to rectification. Again, you can rectify inaccurate personal data by providing a supplementary statement, for example, but how are you actually going to rectify something that is an assessment of you? And so again, in these cases, they tackled this idea of essentially what is the purpose of data protection law, how does it relate to inferences, and essentially what they took, I'm going to skip ahead here a tiny bit, is that in the case of YSMNS, they said the legal analysis is not liable to a check of its accuracy. It's not liable to rectification. The reason is that the regulation is not designed to ensure the greatest possible transparency of decision-making processes or to promote good administrative practices, so that's sort of not within the scope of data protection law. And in Novak, they said, well, essentially you have to take a teleological approach to rights. So if something is personal data, to figure out how a right applies to it, you have to take into account the reason that it was collected, so the purpose it was collected for and how it's being processed. And they gave this example of even though an exam script is the candidate's personal data, it would be absurd to say the candidate can correct their exam script after the exam actually occurred. So even though it's your personal data, you do not have a right to rectification over it. So that's just a summary of sort of the views of both parties about whether inferences are personal data and what they see the remit of data protection law as. And I think importantly, the Article 29 Working Party sees it as data protection law is there to make decision-making more transparent and accountable, whereas the European Court of Justice explicitly says that it's not there to regulate the content of decision-making. Okay, and just very quickly, just sort of at the end here. So again, the thing about rights and freedoms of others, we have a new directive in Europe, the Trade Secrets Directive. And I just want to say that the definition of trade secrets within that directive is incredibly broad. It seems like any information that a company is processing could arguably be classified as a trade secret. And this will count towards denying people their data protection rights. So for example, their right to access or delete inferences that are drawn about them. And so finally, what we propose as a solution to this is essentially that we need to reimagine the remit of data protection law, not just to deal with the inputs into data processing, but also to deal with the outputs, the data created about us. And in doing so, you have to take a sectoral approach because it's really going to find that right balance between the individual's interests and freedoms, or rights and freedoms, and the data controller's interests. You have to take into account context, essentially. And so what we propose is a right to reasonable inferences that would apply to high-risk inferences, so things that are privacy invasive, reputationally damaging, and have low verifiability, so they're predictive or opinion-based. And essentially what the right would require is that some sort of ex-ante justification for drawing the inference be offered by the data controller, which will probably be based on the statistical reliability of the method they're using to draw it. And also a ex post right to contest inferences. So right now you have a right to contest automated decisions. We propose you should also have a right to contest high-risk inferences that lead to the decision. So not just the end point of the decision-making process, but the middle points itself. So I'll end there. Thank you very much.
Thanks. I think that builds on nicely on the previous two presentations, because now we've had the whole world criticizing different aspects of the GDPR and various things related to it. And now Europe is weighing in as well and doing the same thing as well, at least while the UK is still in Europe, but for now at least. I just wanted to ask one thing, because it was very interesting between the comparison when you contrasted the Article 29 Working Party's opinion on inferences and the European Court of Justice. In all of the case law that you showed, for obvious reasons, that was still based on pre-GDPR time. So do you think that it's possible that they will update their understanding now after the GDPR has been passed?
It's definitely possible. Those cases, I think, are from 2016 and 2017. And actually, the European Court of Justice explicitly references the GDPR in Novak. They might also in YSMNS. I can't remember for sure if they do. But in any case, they make it pretty clear that these are forward-looking judgments as well. But of course, they could change their mind in the future.
Perfect, thank you very much. And also cognizant of time, because we're a little bit behind the schedule, and I'm half British, half German, so I'm trying to channel my German side now and be as punctual as I possibly can. We're going to move on now swiftly to Florent. The floor is yours. Should we throw him a microphone? Or? Not yet. While we're waiting, for your enjoyment, Florent and our next speaker, Freya, have considerable disagreements, at least in the pre-discussion, of their various different aspects of what they're about to present. So we've tried to put them as close together as possible in the panel to maximize those disagreements. We hope you enjoy. You like one?
No? That was you. Okay. Right. Thank you so much. Being Swiss, of course, given that you just mentioned timing, I'm under some sort of pressure, of course, to deliver on your expectations with regard to trying to, stick to the schedule. As you mentioned, and maybe I have to disappoint you, I'm not so sure whether we really disagree on so many aspects. But as you mentioned, I will be talking about the right to data portability. And I will start off by trying to come back to the overall topic. Right. Could you turn that off, please? There is no presentation, sorry, just a text. So the overall topic of the panel, as you know, is control, and GDPR, of course, is based on the overall idea that natural persons should have control of their own personal data. You can read that in recital 7 of the GDPR. One could also label this sort of control as informational self-determination or informational autonomy. The idea of control is also, as we have seen, the underlying rationale of many provisions, including the lawfulness of processing based on consent, as will be mentioned later on by Freya, information duties of data controllers, right of access of data subject, the right to rectification, to erasure or the right to be forgotten, the right to restriction of processing, the right to object to processing, and last but not least, the right to data portability, which has been, as we have heard this morning, one of the very few inventions of the GDPR, and which is, as I have said, the topic of my short talk. However, control is not fully established in the GDPR. Rather, it comes with many restrictions. One could even say that these restrictions are so important that the intended control in the end is not really achieved. For example, the lawfulness of processing, as we all know, can be based on the legitimate interests of the controller. In very many instances, in fact, this is the basis for the lawfulness, not the consent of the data subjects. Actually, many companies prefer to rely on their overriding legitimate interests, as they do not have to ask for consent, and they do not have to fear that consent will be withdrawn in the future. In addition, processing is also lawful if it is necessary to perform a task carried out in the public interest. And of course, there are a number of other reasons for the lawfulness of processing, such as performance of a contract, compliance with a legal obligation, and the like. All these reasons, at least to me, seem to be justified. But when assessing them all together, it becomes quite clear for me that the data subject most often has no control over the processing of his or her data. Control is also limited on a different level, since many of the data subject rights come with important restrictions. For example, the right to erasure is only granted if one out of a limited set of situations is given. For example, if personal data is no longer necessary. The same is true for the right to restriction of processing, and there are even more restrictions for exercising the right to data portability, as we will see in a minute. Also, data subjects do not have a general right to object to the processing of their personal data. Instead, such right only exists if the processing of the personal data is based on the overriding interests of the data controller or the public interest, and if the right to object is actually exercised on grounds relating to the personal situation of the data subject, for example, the reasons relating to his or her family life or for the protection of trade secrets. Even if such reasons are given, the right to object is subject to a very general restriction, since the companies and or the government agencies which are actually controlling the data processing may continue to process the data if they're able to demonstrate compelling legitimate grounds for the processing. While this sounds like a very important restriction, such compelling grounds can be given in many instances, as they have to be assessed in a pondering of interests of the controller on the one side and the data subject on the other side. As a consequence, personal data can be processed in many cases despite the explicit wish of the data subject not to do so. This short overview should have made obvious that control over one's personal data, which is the promise of the GDPR and the topic of the actual panel, is very limited. This is not to say that these limits are generally unjustified, but it seems important to highlight that the GDPR is far from granting actually full control over one's personal data. The general aim of the right to data portability is actually twofold. On the one hand side, this right should indeed grant the subject some sort of control over his or her personal data by allowing him or her to receive the data. On the other hand, the right to data portability should also allow users to switch providers, especially social media providers, and to take all their personal data along. In this perspective, the right also aims at fostering competition by avoiding lock-in effects. Some have even argued that the right to data portability should help fostering competition between less and more privacy-friendly service providers. It remains to be seen, however, whether this right will actually be able to serve that purpose. With regard to social media, we have all realized that network effects will probably be too powerful and for the right to data portability to actually make other service providers as powerful as the current ones. Most probably the right to data portability will hardly have an impact on the market entry of new competitors in the field of social media, but this might be different with regard to other services, for example, email services or the services of cloud providers. So from that perspective, this right may well have some impact on the market. With regard to the substance of the right to data portability, however, we need to distinguish three different aspects: the actual rights of the data subject, the conditions for exercising these rights, and the restrictions that come with it. The right to data portability grants data subjects three rights: a right to receive his or her personal data from the controller, a right to transfer that data to a new controller, and a right to have that data directly transmitted from the first controller to a following one, if that is technically feasible. These rights, all of them, are granted if three conditions are met. First, the data subject has actually provided the data, him or herself, to the controller. Second, the processing of the data is based on consent or on a contract to which the data subject is a party. And third, the processing is carried out by automated means. The most important restriction, of course, will be the first one, so it only applies if the data has been provided by the data subject. Finally, the scope of the right, as I said, is limited. It does not apply if the processing is necessary for the performance of the task carried out in the public interest and to the processing in the exercise of official authority. This quick look at the new regulation of the right to data portability clearly shows that the scope of this right is actually rather limited. In addition, at a second look, it becomes clear that this right is also nothing new. The right of access, as contained in Article 12 of the Directive 95/46, explicitly states that the data subject has a right, quote, to obtain from the controller communication to him of the data undergoing processing, end of quote. The right of access stated in the GDPR is very similar and even more explicit, as we have seen on one of the slides that have just been shown. According to Article 15, Paragraph 3, the controller actually shall provide to the data subject, again, quote, a copy of the personal data undergoing processing. The first of the three rights of the right to data portability, which is the right of the data subject to receive his or her personal data from the controller, therefore, is already explicitly contained in the right of access in the GDPR. But as opposed to the right to data portability, the right of access is not subject to any condition. Namely, it is granted irrespective of whether the data has been provided by the data subject and irrespective of the reasons for the lawfulness of processing. As a consequence, the first right within the new right to data portability is actually nothing new at all, and even remains behind the rights we already had prior to the entering into force of the GDPR, and which is clearly stated as a part of the right of access of the GDPR. This is not only true for the first, but also for the other two rights contained in that right to data portability. If the data subject receives the data from the controller based on his or her right of access, there is nothing that inhibits him or her to transfer that data to another controller. Therefore, also the second right within the right to data portability does not grant any additional control to data subjects which is not already granted through the right of access. With regards to the third right, which is the right to have the data directly transmitted from one controller to another, the data subject can achieve the exact same result with the right to data portability if the data subject actually appoints the new controller as an agent to act on his or her behalf and asking the old controller to directly transmit the data to him or her. Taking this into account, it becomes clear that the right to data portability is nothing new at all on a substantive level. Given the conditions that have to be met to exercise that right and the restrictions of the scope, the actual content even remains behind what is already granted through the right of access. However, given that data protection law is also consumer law, explicitly regulating a right to data portability has at least one merit which must not be underestimated. The label of the right is a clear message to the data subjects that they can actually get a copy of the data, transfer that data to a new controller, and even have it directly transferred from the present to a future controller. From this perspective, the right to data portability may actually have an impact in real life, even if it does not grant data subjects any new form of control over their personal data. Thanks a lot.